We're officially official. So uh, do we want to recognize who's on the Zoom connection? I see. Mr. Gino?
So we have Representative Bonner. Those are the only commission members.
Okay. And here we have in person Professor Rago, Professor Mystic, myself, Representative Krajewski, Judge McDermott, Judge McLaughlin, Chairman Fox, got Mr. Volkovich, and Secretary Harry. Everybody. All right. So we'll call the meeting to order, and I'll turn it over to Matt Kleiman. Dr. Kleiman.
Great. Thank you, Judge, and welcome everybody. As I mentioned last evening, we have a pretty robust agenda of a lot of things that will be short, brief updates of work that the commission has been undertaking on a number of different fronts. Unfortunately for the Senior Deputy Director, Ryan Myers, a lot of the lifting today will be done by him. He'll be having a lot of different presentations. And just briefly for the agenda of this meeting, Ryan's going to begin with a review of some elements related to the 8th edition guidelines, and then provide a brief overview of our reporting and verification process, as I mentioned last night, where we work with counties to improve the submission of sentences to the commission, followed by an overview of an extension of the short sentence parole project that was completed previous to the last commission meeting. Brett and Ted Greenfelder will be presenting on that. Ryan will be back talking about the new probation reforms and what he's learned by talking to stakeholders across the Commonwealth. And then Bobby and I will talk about two new initiatives, one being related to community engagement that the commission, especially the education and outreach unit, may be undertaking, and get for both of these initiatives, it would be great to get input from the commission about what the shape or how these will look in practice if we were to implement them. And the second, as I mentioned, are these, what I'm kind of referring to now as data snapshots, very visual, data-oriented, 1 or 2 pagers or a short piece on the website, digging deep into one specific issue. Could be something like a case type in particular, what the distribution of sentences look like. It could be on a specific topic, and we'll provide some examples later. But again, looking for how that may work in practice. And I think it's also just worth emphasizing for both of these initiatives, the subcommittees that we established last commission meeting, this is a great opportunity for staff to meet with them midstream between the commission meetings to get, again, insights from some commission members about what these efforts might look like, review drafts and so forth, as opposed to presenting that to the whole commission. So with that, I will turn it over to Senior Deputy Director Ryan Myers.
Thank you, Matt, and good morning, commission members. As Matt noted, I'm going to spend a few minutes here overviewing some not modifications, but some corrections to the 8th edition offense listing. And I just thought I'd start with just a little bit of history. I know we have some new members, and I wanted to give you an appreciation for that. Anytime that the commission adopts an addition to the guidelines or amendments to the guidelines, there may be mistakes in what was published, typographical mistakes, a misgrading of an offense, the wrong OGS based on policy, as examples. And historically, what the commission has done to remedy those mistakes is make use of an errata sheet. And this is something that's been done certainly in my time at the commission, about 12 years now. And you can go back on our website and see that I believe for about every edition, you will find what's referred to as an errata sheet. And it lists corrections to the offense listings. And so what I wanted to do was just go through some recent mistakes that were found in the 8th edition offense listing, particularly around BUI and DUI offenses. And I'd note by saying that, staff, since the adoption, and we've been working with counties, have been taking time and care to review this information. And also, as we engage with practitioners throughout the state, much the education and outreach unit, we receive inquiries. And actually, what sort of prompted this more in-depth review was an inquiry we received from an ADA in Western Pennsylvania, asking us to look at a grading of an offense for a DUI. And so the three areas that I'll highlight here for you are corrections specific to the grade of an offense, the corresponding OGS for that offense, and so forth for the prior offense group. And we'll go through these. And I don't want to spend a lot of time on going through every single one, but I thought it would be helpful initially to just give you this sort of high level view, because as we continue with the 8th edition and it has over 2,500 offenses, there might be future opportunities to correct things. And so this might be something that we engage in over the course of time moving forward. But I just wanted to at least make sure that the commission understood sort of our process in doing this and how we make those corrections available to practitioners and to the public. And so for the DUI and the BUI offense listing, the three main areas that we're looking at, and particularly was initially for third-time DUIs, where there was a minor occupant in the vehicle. And in the offense listing, we have a lot of detail around DUIs. And as you can appreciate, the statute has a lot of details and moving parts when it comes to DUIs. And we had misgraded the third-time offenses in which there was a minor occupant. We had it as a misdemeanor 1, and by statute, it's actually a felony 3. So anytime a person has 2 or more prior offenses and there's a minor, it elevates that to a felony 3. And we just made that mistake in the offense listing. And but we consistently made it. So, that there's something there. And then what we had to do was, when we looked at, correcting the grade, we also had to look at making sure the offense gravity score was also correct. And I just wanted to remind members, because, we undertook a really, detailed review for the 8th edition and made a lot of decisions. One of the things that was done for DUIs and BUIs was to link the offense gravity score to the mandatory minimum penalty provisions in statute. And so as we went through, we wanted to make sure that we had the grade correct in these offenses and the corresponding OGS linked to the mandatory minimum. And I'll give you a visual representation here in a moment to make sense of all of this. But that's consistent with the policies adopted by the commission and outlined in the text of the guidelines. And of course, when you correct something in one place, you might have to also correct it in another. And when you're correcting the grade of an offense from an M1 to an F3, we also needed to make sure that the prior offense group assigned to that offense was correct in the offense listing. And we looked to the guidelines for the description of that. And so briefly, here is a snippet, and I apologize, it's not easy to see, but this is the omnibus table for DUIs in the text of the guidelines. And this is just to illustrate to you all that the offense gravity scores are indeed linked to the mandatory minimums. And you'll see there on the left-hand side in the columns, the various mandatories we have in statute for DUIs, and then the OGS assigned for those. And then we also have a policy that allows for any time a grade of an offense is increased, but the mandatory doesn't change. You see that from a felony 3, or misdemeanor 1 to a felony 3, where they sort of retain this 90-day mandatory minimum, but the grade is elevated. We make sure that we elevate the offense gravity score sort of commensurate with its other felony 3s as an example. And then as I noted on the slide of grade and offense gravity score and prior record score, we also just look to the text to make sure that we know what the prior offense group is for felony 3. And as we work through the 8th edition, the policy that was adopted was that for felony 3 offenses that are not designated as a serious crime, such as a DUI, they are a prior offense group 2 offense. So with that all being said, I give you just a quick visual here of the offense listing as published, and the highlighted area represents where our mistake was. And this would be for a DUI, as an example, general impairment, where it's a third-time offense and there's a minor occupant present. And we had 2 of those offenses graded as misdemeanor 1s, and they should be felony 3s by statute. And so we went through this and wanted to make sure that we had the corrections. And so this is just an example of the areas where we will be correcting through the use of the errata sheet. It will be changing the felony misdemeanor 1 to a felony 3. And then we also looked at the offense gravity score and recognized that we had that incorrect based on the policies linking to the mandatories. And so we'll make the correction for the OGS 9 there. And because it is changed from the M1 or corrected from the M1 to the felony 3, it would change its prior offense group. So a little technical, but just wanted to make sure that you had appreciation for, these changes. And, it may occur again as we have, 2,500 offenses to keep track of. But I wanted to give you two other quick examples as we go through. Here's an area again with the third offense, and you can see we have the offense gravity score correct, but we didn't have the grade correct. And so again, it's just a fix of correcting from a misdemeanor 1 to a felony 3 and its corresponding prior offense group. And then the last example would be just incorrect, typographical errors when it came to the OGS assignments. It's a copy paste mistake. And we identified those. And so we'll make sure that we're correcting those consistent with the policy aligning to the mandatory minimum. So that was a lot in short order, but I wanted to at least make sure that we provided it to you in that information. And the last thing that I'll mention on this topic, and then we'll move on to reporting and verification, is that we will make these changes in SGS Web. So after this meeting, staff will be working to make sure that we have all of these corrections in SGS Web, which is the primary area in which practitioners access the information. And of course, we encourage them to generate the guidelines through SGS Web. We will also publish the errata sheet on the Commission's website under the 8th edition guidelines, and we will have that sort of nested in with the BUI or DUI offense listings or pretty prominently noted there on the Commission's website. So that information will be available. And then the last thing I'll mention is for an effort for Bobby's unit, education and outreach, they build this into their routine trainings for practitioners to make sure they understand what information is needed to appropriately apply the guidelines. So thank you for starting off the policy meeting with that, and I'll give it to
Ryan, I
Judge
just
quickly.
want to thank you for your work in this. I will say this, the statute, we had a call about this. It's not easy to read, and it took me 6 or 7 times, and I'm still not sure I quite understand it, but it was easy to see how the mistake was made, whether it referred to a third offense where you had a child in the car as opposed to a third offense DUI. And I think it speaks to the commission's staff, their ability to interact with practitioners across the state. Kudos to the attorney that caught this, and recognized it. It's going to be a rare occasion, where one guy's going to have a case like this, and that's going to be the one that calls in and lets us know. But I think it speaks to the commission's relationship with the practitioners, that somebody out there is like, hey, take a look at this. Ryan got right on it, and corrected it. So thanks for that.
Thank you, Judge. Okay, I'm going to turn it to our executive director for a moment, and then we'll pick up with reporting and verification.
Yeah, and thank you, Judge. I think that this has been a good example of the communication between the folks in the field and the commission staff, and then staff being able to work with commission members to find a resolution. So with Ryan working with Judge Marsico, reaching out to other attorneys and district attorneys that he knows, really digging in on this issue to make sure we make the appropriate correction. So big thanks to Ryan on that. Before we go to the next item on our policy agenda on reporting and verification, I just want to highlight 2 things. One, I mentioned at the dinner last evening, and that's that there was a amendment adopted this week related to Senate Resolution 196. And let me just read really quick the brief part of the resolution, directing the Pennsylvania Commission on Sentencing to conduct a thorough and comprehensive study on the effects that post-traumatic stress disorder or injury, military sexual trauma, and traumatic brain injury have on service members, veterans, and their families who are directly or indirectly involved or implicated in any portion or component of the criminal justice system. When this resolution, the first drafts we saw, suggested that the commission would complete this project and deliver a report within 6 months. And so we've had discussions at previous meetings that that wasn't very feasible. Working with some folks in the Senate staff, the amendment essentially changed the duration from 6 months to 15 months, which was much more appropriate to do the comprehensive evaluation that they're requesting for us. So we are operating on the assumption that this will be passed soon in this session in the Senate. And I think that one thing I haven't mentioned to the commission at large is this may be a project where we consider impaneling an advisory board. And other commission projects, I believe the mandatory minimum study that was done 15 or so years ago had an advisory committee. And there's real value in that because we're going to be requesting and obtaining data from various sources. And there's lots of different touch points in this, of course, in the criminal justice system where veterans will be involved. So I'll be working and talking once this passes with the chair and seeing who might be chair that subcommittee from our commission members. And then, for example, like having a representative from the Department of Military Veterans and Affairs makes sense. Somebody from the Department of Corrections makes sense, et cetera. So how best to convene that, where we would meet, how regularly we meet, we'll work those details out. But I think this is a very large scale project where we would benefit from having input and help shape the research design, but also us going out and making site visits and meeting with the appropriate people and obtaining the correct data. So just on that, when we thought it was 6 months, and I believe I reported out on this last time, we were trying to get a head start. So Brett and his unit were doing a lot of digging into what risk or what tools are available to identify post-traumatic stress disorder. We went and made a site visit to Cambria County. We met with the Veterans Court judge there just to find a little bit about that program. We also met with DOC staff and heard a lot about the programming that is available at DOC, not as a formal final step in this evaluation, but just to get our understanding of the landscape of things we were looking at. So more to come on that when we find out if this resolution is passed. The second item, I just want to give a brief update on efforts related to our budget request. I want to thank the chair and a number of other people on the commission who've been really helpful to me in thinking about a strategy for approaching our request. As you might remember, we've had flat funding for 5 years, and we're making a request for 3.6 million, an increase from 2.5 million. So in addition to the chair, I've been working with Judge Marsico, Senator Langerholtz, Representative Bonner, and Judge Daly, and Professor Mystic on thinking about what steps need to be taken. So with Representative Krajewski, we met with Chairman Briggs, Leader Bradford, staff from the House Appropriations Committee, staff for Senator Hughes and Senator Pittman, the executive director of the Senate Judiciary Committee. Later this week, we're meeting with the Secretary of the Budget in the governor's office, hopefully be meeting with the Speaker of the House later. And also want to thank Secretary Harry, who submitted a letter on behalf of the commission to legislative members in support of our budget requests. So we'll see how things shake out, but I, again, really appreciate all the insight and support from everybody related to this matter. I think it's a critical moment for the commission in regards to funding. And one of the functions of the June meeting is to essentially close out the prior fiscal year and approve the operating budget for the next year. You'll get a sense of why, and we've talked about this, of course, in the past, that these funds are necessary for the commission, especially as it relates to thinking about flat funding and what it would be relative to our operating expenses. Okay, with that, I will now turn it back to Ryan. Thank you.
Thanks, Matt. Turning our attention to the discussion about reporting and verification. As you can see here, I have it listed as, a yearly effort. And for some of you, you have heard me talk about this each year. And I gave a brief update in March, and I believe Brett had talked a little bit about some of the early efforts from his unit. But one of the things I thought I'd start on and just say is that this is a really fundamental project that commission staff undertake each year. And the information gained through this, the data received, it really is how the commission does its work. When we created the 8th edition guidelines and we're looking at, all of the sentences for a given years, it's really through this process and this project every year. And it also took, back at the end of 2019 and early 2020, it took on a little bit more prominence for counties, I think, after the legislature passed that JRI 2 legislation, in which it required the reporting and sort of linked the reporting to funding for county intermediate punishment programs and so forth. And since then, staff and Bobby's unit, the education and outreach unit, have worked really closely with counties to increase their reporting percentages of sentences in particular. And that's what I'll be focusing on. But I also will talk a little bit during this session about resentencing information. And then also during the probation reform discussion, I'll talk about the collection of resentencing and information and how that's really vital and important to the work of the commission. And so I'll give you a sort of a project overview and a timeline of this year. And then we'll actually, and Matt made some very nice slides for me to use to illustrate visually just the changes from sort of pre-project efforts and post-project efforts with counties. And I think you'll understand that the work that staff are doing is important to the information that we're receiving. So I just wanted to take a moment and say, while I'm reporting out on this is really a full agency effort, and the managers of the respective units on the screen all deserve a lot of credit in this. Each, they take a part of the project and they dive in and they oversee their unit working on all of this. So I have to thank each one of them here. I won't read all their names, but they're on the screen and I thank them, and many of them are in the room. But I'll give you just a highlight that for the research and data analysis unit, it really kicks off in the beginning of the year, and they do a preliminary analysis to identify cases reported to the commission or not reported to the commission. And that sort of sets the stage for first looking at what information the commission has in comparison to AOPC. And then the applications and information technology unit provides a little extra information on reported versus not reported, but then can give information on our cases in SGS Web and what's the status of those cases. And do they just need to be submitted, or are they, not there at all? And so that's a layer added on to this process and makes the information even better. And then the education and outreach unit does an internal review of that and, removes cases that shouldn't be on the list. If it's like a PFA or it's a summary offense that's sort of snuck through, or it's a magistrate that's sentenced and not a common pleas judge, and so forth. And so they do some sort of initial look at the data, and then they engage with the counties themselves, the actual individuals that are, identified as reporting the information to the commission, those practitioners in the counties and the judges themselves. And so they're sort of on the front line of working with individuals in the county and are our direct contact there. And then the administrative and financial support unit, we have to thank them because they handle all the email communication and get all this information out to our 67 counties. And so it is a complete agency effort to bring this to fruition each year. And so why talk about it now? Well, June is usually, the end of May, I should say, is when this project really ends. And it does take those first 6 months of the year to do this. And I'll sort of explain why that is as we go through. And June has become the time that we as staff report out to the commission on county reporting percentages for sentences. But as you can see here in January, that's when counties have their initial reporting deadline. And that's as defined by the guidelines that counties are to report their sentences within 30 days of the sentence. And so we always think of, January 31st as the deadline for the preceding year. So January of this year, they should have all of their 2023 sentences in by that point. In February, Brett and his unit do the preliminary analysis and this comparison between information that we receive in our SGS Web application compared to AOPC's CPCMS application, and to make sure we're identifying those missing cases. So we know what we have, we know what AOPC has, and then we're matching by OTNs to identify any missing cases. And then that's where those other efforts come into play as well, with the applications unit and the education and outreach unit taking those, like February and March to really work through this data to make sure we have a very clean report to give to counties as an initial analysis of their reporting percentages for the year. And we try to make sure that we have that information provided to counties by the 1st of April each year. And we give counties the month of April to go through what's called the reporting and verification process. And this is sort of twofold. One is report what you haven't reported, certainly, but it's also an opportunity for counties to verify that the information that was reported or that they will be reporting is accurate and that it's complete. And so the education outreach staff, this is where they engage in a big way with counties to help individuals submit cases or, remedy issues if they're having technical issues in the application, but also help them run reports in SGS Web and just have a better understanding of their individual county data. At the end of April, Brett's unit then does the final analysis, and it's during May that we have a real clean picture of what a county's full reporting looks like for that given calendar year of sentencing. And I'll share some slides with you here in a minute. And I'll remind you that back in, I want to say 2021, the commission adopted an initial, or I guess a preliminary sort of certification of compliance protocols. And at that time, the commission identified an 85% threshold to determine full reporting of sentencing. So when I talk about full reporting, it doesn't necessarily mean that they're 100%. We're certainly striving for that. But it means that they've at least submitted 85% of their sentences for a given year. And that's allowing the commission to have a pretty good pool of data to begin to certify compliance with reporting and other programs in a county. And I'll come back to that theme as we go through. And then in June, as I mentioned, we're talking about it now and we're providing you the information. It's also in your notebook materials and supplemental. And then post the June meeting, actually tomorrow, Bobby and I will be working on drafting up the final reporting percentages communications to provide to all president judges, administrative judges, criminal court judges, district court administrator, and the chief probation officer to let them know, like, here's where you were for 2023. And then we also use that as an opportunity to have just continued dialogue if a county's sort of struggling or identify areas in which we can help them overcome, roadblocks to reporting if it's sort of consistent year in and year out. And I'll move off this slide momentarily, but I'll just give you an example. And this gets really to the ground level for a county. Sometimes you'll see a county who historically has high reporting, and then all of a sudden it's really low. And it could be as simple as the single person responsible for reporting in that county retired, and they just haven't filled the position or they haven't trained the person. And so it's oftentimes not a willful, like, we're not reporting the information. It's just a process in working with counties. And so we want to make sure that from the commission standpoint, certainly from a staff standpoint, we're engaging with counties and we sort of have a temperature of what's going on, and we can support them in getting that information in. So with that being said, here's some visuals of 2023 sentences imposed. And I'll start with, these slides are sort of pre-annual reporting and verification efforts. So this is Brett and his unit's initial analysis in that February-March timeframe. And what we see at that time is that 89% statewide average. And so you can also see this distribution of counties where we have a number of counties that were below the 85% threshold at that initial time, which was set by the commission. And certainly we have a large number of counties that are above it, several that are at 100% reporting, but not the vast majority. Yeah.
Just for interpretation, we sorted the data on reporting here, so we're not singling out any county. So they're listed 1 to 67, but they're from low to high on this initial reporting. So the number 1 is not the alphabetical order. It's just the lowest reported county in this example.
Thanks, Matt. And as you can see here, 7 counties were at 100% initially when we did the analysis. 35 were at 96%. And so, a good portion of counties are at early part of the process are already above what we're asking them to be and pretty close to 100%. But then we have these other counties that are below 85% and some significantly below. And these could be counties with just a few sentences. You have some pretty small counties in Pennsylvania And if they don't report 10 sentences in a year, that's a pretty significant impact on their percentage. But then we also have some pretty large counties. And when you think about that, if they're low in the percentage, that's a lot of sentences that we're missing from a data standpoint. And so we're working with these counties to increase that clearly to help support full submission and information to the commission. So this is a visual of what it looks like from a percentage standpoint after staff's efforts with counties. And you can see, obviously a real increase here from below reporting to above, and really high percentages as you look at it. And what we found for 2023 at the end of the analysis for the year was a statewide average of 96%. And so pretty good. There's always going to be some cases here and there that we might not receive or cannot be reported for various reasons. But what I think is really helpful to see, and not only is it a change in, I think, what was it, 7%, but it represents almost 7,000 sentences. And so that's information that if we didn't undertake this effort, we wouldn't have that year in and year out. And so we would be missing really vital information. Just some other data points for you. 19 counties, 100% of their sentences were submitted, and 56 of our 67 counties overall had a 96% or higher. So I think that's really positive for the Commonwealth and the counties reporting information to the commission. And then I like this slide that Matt created, and just to show you how much movement. While some of those counties initially were above the 85% threshold, what I think is helpful to note here is they're still working, right? They're still working to get that information in, even though they've met that threshold. And so we do see really significant increases in some areas. And here's just an example of the work that Bobby's unit does to take a county from 59% reporting to 93% reporting. So great stuff there. 47 of our 67 counties, after we sent the information in April, reported additional information to the commission.
Brian,
Yes, Judge.
historically, what would we have seen prior to the requirements that tied it to the funding, like 7-10 years ago? What were the percentages of reporting that back then?
And I wish I could answer that. Prior to this, we didn't do percentages.
All right.
But we did engage in this and identify cases missing. And I remember when I first started with the commission, it was much more painful process where we would search cases by OTN, all, hundreds and hundreds and hundreds of them. We didn't report out on percentages, but let me just jump ahead a slide here to say in the last, 5 years, we've seen an increase of 3 to 4% from that initial, from 2019 till now. But I'd suspect when we first did this, it was pretty low for some counties, and I would have suspected that the overall average for the state would have been much less than what you see here. But maybe we could take a look into that just as a little side project, if you'd like. But yeah, thanks for the question. And I'll give an example. I won't, name the county, but there were some counties, actually multiple counties, in which when we first engaged in this process back in really 2020, looking at 2019, they were in the 30s and 40% of reporting. And so, that wasn't changing necessarily that much when we would engage in the annual process. And so both JRI2 and the work of staff and the commission, I think, has really elevated the reporting information. And let me mention just one piece here, because I skipped over this slide quickly there. For the JRI2 reporting and certification of compliance, while the commission set this threshold of 85% or higher, one of the things that the staff had recommended at the time was sort of giving this gradation to have a county understand, well, yeah, if we're above 85, we're full reporting as defined, but are we like high reporting, medium reporting, or low? It's sort of like A, B, or C, how well are you doing? And they can grade themselves. And just anecdotally, in speaking with counties, they take a lot of pride in what they're reporting. And we obviously publish this information on our website. We're talking about it in a public meeting. And I think this is a nice way for counties to sort of compare themselves to, I always refer to like your sister counties. What are your like counties around you, and how well are you doing? And as you can see here, pre-process and after process, 56 of our counties are reporting in the high level, which is 96% or above. And I think I looked, and I don't remember now, but 20 some counties shifted from into the high level, which is really, really helpful for the information that the commission receives. I have one final slide to talk about here, and I certainly open it up for any questions or discussion. And this is not for you to read. It's just a visual to say, in addition to the information that we send to counties as far as their reporting percentages and files of missing cases or unreported cases, we also undertake a county contextual update each year, in which we are asking counties to provide us updated information on their sentencing practices. And this has been a long time practice for the commission. Because the commission makes information publicly available, it's also helpful to make publicly available information on what programs are available to courts. Do they have treatment programs? What are their sentencing practices in that county? That way, if someone's accessing the information on our website, they can also look at what are available resources to that county. And maybe that explains a departure rate in certain areas because they're making use of a problem-solving court in which the commission historically may have recommended county confinement as a starting point. And this year, we updated the survey, as you can see here, and sent it out to all counties. We are currently working through figuring out what all was reported to us. Unfortunately, not all counties are reporting back on that, but we're sifting through the information we receive. And later this summer, we will update all of that information on our website, and it can all be found under our research and data analysis and JRI2 and county contextual. So if you have any questions, if your county reported or not, just let me know and we can look into that. So I think that's wrapping it up for me on this. I'll mention one other aspect, and I'll pick back up on this when we talk about probation reform. But our primary focus over the last 4 years has been to make sure counties are fully reporting sentencing. One area in which we maybe didn't provide or focus on as much was the reporting of resentence information for the revocations of probation. And we do receive those. We do receive reporting of that, but we have a pretty strong inclination that there's underreporting. And we are working, and Brett's unit's done a nice job on some initial analysis to try to create a system very similar to what we do with the sentencing data to say, here's a resentence reported to AOPC. We don't have it for that OTN, and working with counties to get that information. Unfortunately, it's not as easy as it is for sentencing, if I'm channeling Brett, but we're working through that. And one area I say we think there's underreporting is we know there's counties that are reporting 0 resentences. And while I wish from a policy perspective that were true, I suspect that there isn't a county that has 0 resentences. We do have some counties that report a few resentences. But when you look at the size of a county and the number that's being reported to us, you kind of get is it passing the smell test, as I'll say. And so we will be engaging much more with counties and making sure they understand that that's a requirement to report that information to the commission. Can you hit your mic, please, Professor?
Okay,
There
sorry.
you go.
In Allegheny County, I know our district attorney has a relationship with the U.S. Attorney's office with respect to certain gun crimes, charges, et cetera. That may impact data as well. So I don't know if the DA should be a part of that solicitation in terms of any arrangements with U.S. Attorney's offices. It's just unique maybe to Allegheny. I'm not sure.
When we first send information to counties, I'll talk sort of generally about this process. We don't include the DA. And the reason for that is it's the court's responsibility to report to the commission. But what we do in counties, because we understand that it varies who is responsible for it. In some counties, the DA is responsible for generating and reporting. And so we always are trying to make sure that we're reaching out to them sort of subsequently to say, hey, this information was provided to the court. What can we do to assist you? But we're happy to engage. And
It's just a thought. I
Yeah.
thought you might want to know.
I appreciate that. Okay, that's all I have. I'll turn it to the executive director for some comments.
Yeah, I think this is an amazing illustration of the work that the whole commission staff does to increase the submission of the sentences. And just want to highlight, like, why is that important to us? And of course, for the commission and Brett's unit especially, we're asked to do evaluations of what programs work. We're asked to provide a profile of sentencing practices in the Commonwealth. And clearly having complete or more complete data is really important to us. And so if we're going to be looking at changes from year to year, changes from the 7th edition to the 8th edition guidelines, and we'll go back to that earlier world where Ryan mentioned some counties were at 30%. How much confidence do we have in that data? But when we're at 97, 98%, it's somewhat like thinking about a survey and you said, hey, I had 10% of respondents. You'd say, how good is that? 98% of respondents, you have a pretty good understanding of what's happening. And I think that those efforts at the individual county levels, we don't do a lot of work focused specifically on one county because, we want to generalize practices, but having those larger counties at low rates could really impact the findings that we have. And I'll just highlight one example on the resentencing, and I think this will be a big initiative for the commission to improve those rates. When I joined the commission 2018 or 2019, we engaged in a project that looked at substance involved offenders and resentencing and technical violations and new arrests. We didn't know what the universe of resentences were, but we kind of used the threshold and we only examined 47 counties, I think, of the 67 counties because many had 0. So if they had a very small number, we didn't include them in the study. So it was a valid sample and we had a broad swath of counties in the Commonwealth for that study, but it would have been great to have 67 counties reporting us that information and then be looking at county classes combined and aggregating those together to see if there were differences in practices. So this is really important for us, of course. And I think that all the work that the Brett's unit does on analysis and comparisons and trends over time, again, having valid and reliable data and not missing data is just really, really critical for us. So I think the 95% threshold and seeing that statewide average is now 96%. We've kind of met our mission, if you would. We'll continue to beat the drum. It'd be amazing to have 100%, but above 95% is amazing. So with that, I think we'll pivot and actually talk about using some of this data now for the extension of the short sentence parole project. And Brett and a staff member, Ted Greenfelder, have been working the last few months on this extension and learning some new methods that we won't go into great detail about, but that allow us to compare apples to apples between different groups of individuals to see if we can control for a lot of things. Can we see if there's a difference between, let's say, prison and jail and what type of outcomes they have? In this case, our outcome will be recidivism. So with that, I think Ted is going to share his screen. Brett will begin the presentation.
Good morning, everyone. Today, we just wanted to give a short follow-up to the short sentence parole evaluation that we conducted last year. So I'll give a quick little intro and a little bit of background, and then I'll turn it over to Ted Greenfelder, who's joining us remotely. Ted's one of our analysts on staff, and he's really done most of the work for this project. So just to give a quick reminder of what the short sentence parole program is, it's a program at DOC that started with JRI 2, I think went into effect around the end of 2019, early 2020, so relatively young still. But the way the program generally works is anyone at DOC with the aggregate sentence of less than 2 years and meeting certain offense type requirements is automatically eligible for this program. And it's a pretty simple program to operate in the sense that there is no real treatment. There's no rehabilitation component of the program. It's just either you're eligible for it or you're not. And if you're eligible, then at the time of your minimum sentence, you can be released on parole, sort of foregoing the standard parole interview process. So you don't have to do an interview. There is a administrative review by parole board staff. But generally the program is very easy to operate. And in our evaluation, we found some pretty positive results. So we found that it's almost no cost to operate, like I said. And in terms of recidivism, these offenders who tend to be eligible for the program automatically are low risk just based on the nature of the qualifying criteria for the program. So recidivism rates are very low. Cost savings to DOC, cost savings to the parole board for foregoing these parole interviews, and really no extra risk to the public for releasing inmates early. So all in all, we found a lot of positives to the program. There was sort of one question we wanted to include in our evaluation, but didn't have time to. And that was, if these are low risk inmates, might they have been better off staying at the county level in the first place? Or is this program really providing any sort of extra benefit that's leading to this low recidivism rate? So this follow-up study, what we did is we took a group of county jail inmates that were similar to the short sentence parole cohort. So they had all the same offense eligibility requirements. They had these relatively short sentences, but we kind of compared them to the short sentence parole participants. And together we had this spectrum of individuals who sort of reasonably could have gone to county jail or also reasonably could have been sentenced to state incarceration. And so try to make an apples to apples comparison, looking at this entire group. How would the entire group have done with either outcome, either being sentenced to county jail versus DOC and then participating in short sentence parole, and really trying to figure out, is there a real effect to this program? Or maybe these are just happen to be low risk individuals. So that's sort of the concept that we're trying to study here. And with that, I'll turn it over to Ted and he can sort of walk through the study and our methods.
Great. Thanks, Brett. Good morning, everybody. Hope you're doing well today. So Brett gave a great overview of everything. I'll just first briefly talk about these sort of sample conditions of the people we are looking at in this report. So we start with our SSP sample, and these are all the same folks who were in the 2023 report. So their incarcerations began in 2020. They met all these statutory requirements for enrollment in the SSP program. And then we took those SSP individuals and located the charge within our own data that was related to that DOC incarceration to get the specific information about their charge. To have a group to compare that to, we created this jail sample. So we also went back to 2020 for that group. So we look at 3 years of PCS data, 2020 to 2022, only convictions to with a sentence to county confinement. We selected people with a maximum of at least 12 months because we wanted to get sort of the more serious end of jail confinements. We didn't want people who were, getting sentenced to 30 days in jail. And then we required that they have a minimum less than 12 months so that they would definitely be these sort of edge case folks who were right on the cusp of being able to go to prison, but ended up being confined in jail. And then, of course, we removed all of the SSP ineligible charges. So I think we started with a pool of around 30,000 convictions, and then we winnowed it down with all of these criteria. Of course, to do all that, we need to sort of thank our data sharing partners, and so I'll go through the process of how we created these two samples. For SSP, we started with the list of folks that DOC gave us who actually participated in SSP or were enrolled in the program. We matched that to our own PCS charge information. We got their exit date from DOC confinement, and then we used Pennsylvania State Police arrest information as our recidivism measure. And so this measure is arrests within a given time period, which I'll talk a bit more about later. But it's arrests in a given time period that then lead to a conviction. So if we're looking at recidivism at 12 months, the arrest occurs within 12 months of release, but that arrest then eventually needs to result in a new conviction. Creating the jail sample was a bit more straightforward since it was all out of our own data for the most part, but we start with those jail sentences I talked about, get our own charge information. We use the minimum date off of their confinement information as their release date. And then we use the same measure of recidivism for both sides of the sample. I'll talk about how those samples are similar and different here for a little bit. We ended up with 11,700 jail sentences. Again, winnowing down from about 30,000. So of all these, maximum of at least 12, minimum of less than 12 months, folks, only about a third would have been eligible for SSP had they been in prison anyway. So that's 11,700 compared to just over 1,500 folks from our SSP sample. SSP is a little bit less male proportionally than the general jail sample, and they're also a little bit more likely to be female. The proportion of SSP that is white is a little bit higher than in the jail sample, with sort of discrepancies in the other racial categories to meet that variation. Age at offense, average age at offense is exactly the same, or not exactly the same, but very close to being the same. And this is age at their original offense, not at their recidivistic offense if they had one. And then one of the first places where they differ significantly is at OGS. So the average OGS for the SSP sample is 1.2 points higher than for the jail sample. So we are sort of starting to look at people who are a little bit higher on the grid than the jail sample folks, which I'll talk more about how we sort of try to alleviate that difference as we get into the analytic strategy. And then they also differ a fair bit on their offense type. So the folks who are in SSP are probably men, but a little bit less likely to be men than the jail sample. They're more than likely white. And they're probably committed for a drug or a property crime, whereas there's a different distribution of the offense types for the jail sample. Looking at prior record score, distributed pretty widely for both samples, but we see that at PRS 0 is 27% of the jail sample had a PRS of 0, whereas now we look at a more serious PRS and 30% of the SSP sample had a PRS of 5 compared to only 24% of the jail sample. Then we see also a more stark difference on the misdemeanor or felony grading of their committing offenses, with almost 70% of the SSP sample having a felony, only 40% of the jail sample do. Pardon me. And then this is how they're sort of split across the county classes. We see really low sort of contribution of individuals from the first and second class counties. So we pooled them together for this analysis. And then we see a pretty wide distribution of county class for the sample. So all that's great. And this is sort of the recidivism that we observed for those two samples. So I think the first thing to note is that both samples are doing really well. Across every point, the SSP recidivism is about half the rate of the jail sample. But if you, this number is from our 2023 report, at 12 months, we had a general population DOC sample. And at 12 months, their recidivism rate was about 19%. So, we're seeing about half of that for our jail sample here, and then half of the jail sample for the SSP sample. So this is interesting. It's good to know. But I've sort of just described how our samples differ in a bunch of ways. And we want to sort of account for that difference to get a more comparable and hopefully generalizable sort of expected recidivism rate for other people who are going to go through SSP in the future. And to do that, we have this analytic strategy. It has a few things we need to consider. So we want to talk about our recidivism periods a little bit. We can actually only look at recidivism at discrete time points with this method. So in this case, we'll be looking at 3, 6, 12, and 18 months. And the method we use is called inverse probability of treatment weighting, which is a fairly technical analytic method. I spent about a month reading about it and implementing it for this project, but it boils down to a two-step modeling process where we first look at the probability of confinement type. So, a general person going through the system, are they likely to end up in jail or in prison? Of course, they need to be in prison to be processed through SSP. And then we look at predictive recidivism rates after that first step of the modeling. So we'll go through recidivism rates by confinement type from jail and then through SSP. We'll look at that over the discrete time periods of 3, 6, 12, and 18 months. And then we're able to calculate a program effect for these weighted samples. And I've been talking about weighting a little bit here. So this is just for illustrative purposes, our artistic rendition. So we have our jail sample, which is quite a bit larger than our SSP sample. And then we have, variability in who is likely to go to jail versus who is likely to end up in SSP. And we first calculate that probability to weight the sample and give, different individuals' data points more weight in the analysis, which is pretty abstract and high level. So we're then going to sort of walk through a bit of an example with PRS to describe what exactly it is we're doing here. So this is PRS, which we talked about in the sample descriptives, and there's a bit of a distribution variance between jail and SSP. So if we look at PRS 0, jail is light blue, SSP is dark blue. And we've got 28% of the jail sample with a PRS 0, only 17% of the SSP sample has a PRS of 0. And then at the other end, we have a sort of a flip-flop of that difference, and it's a smaller difference. So at this end, the SSP has a higher proportion of PRS, jail has a smaller proportion of PRS 5. The way the weighting works is on the left side, we have our unweighted sample. On the right side, we have our weighted sample. What this does is sort of lower the disparity across these variables. So in the unweighted sample, the jail sample has like I said, 28% of them have a PRS of 0. In the weighted side, on the right side, the jail sample, comes down 1% to 27, but the PRS 0 of the SSP sample is sort of brought up to 23%. This is just a statistical method of making a more apples to apples comparison, sort of bringing down variation on these variables for the two samples. And the sort of upshot of all of this is we're able to compare recidivism rates for these two weighted samples. So these are the 3, 6, 12, and 18 month recidivism weights for these weighted samples. And at 12 months, we expect to see about a 10.6% recidivism rate for the jail sample and a 7.2% recidivism rate for SSP. And it's a little smaller down at 3 months recidivism time. But from 6 months to 18 months, it's about a 3.5% reduction in recidivism for the SSP sample, so across the time periods. So I guess just some highlights from the original report and from this extension. Important to note, SSP recidivism is lower than jail recidivism in this study. It's still a young program and future evaluation is needed. So, I talked about 3, 6, 12, and 18 months here. Sort of the gold standard for a recidivism analysis is 36 months or even longer. So we'd like to come back and look at this again once the program has been around for longer and we're able to look at those sort of longer recidivism tails for people. But it does look like the statutory requirements of SSP are selecting low-risk individuals. These people are doing really well when they return to the community. From our 2023 report, we're seeing low misconduct in prison for the SSP folks. We're seeing low recidivism from our original study, and then again here. And then it's a cost savings program where people are getting out sooner, having to spend less time in parole hearings and saving time for the parole board. And then sort of our future directions we'd like to look into. I mentioned a bit already that we'd like to reevaluate with longer follow-up periods. We'd really like to get a sort of 36-month good cohort review of recidivism for the SSP individuals. And then we'd also like to investigate different types of recidivistic events. We want to see if the folks who are coming out of prison through SSP are, when they do recidivate, is it for something more or less severe than what they went in for, or sort of what type of pattern can we find in different sorts of recidivism events. So yeah, that's all we've got for this today. Thank you for your time. If you have any questions, I'd be happy to answer them.
Representative Krajewski.
Thank you. Thank you for the presentation. It's very insightful. I know you said that the gold standard for this kind of study would be like 36 months. So I know this
Yes.
is still sort of kind of early data. But was curious about if you have any expectations on how you expect that data to trend with recidivism rates with 36 months, or is it too early to tell?
Yeah, so let me kind of put this in a nutshell first, maybe if I can. So what we really wanted to do, like I said, it's the idea, how would these people have done had they gone to jail instead? And so,
Hey, Brett, sorry, can you see if your mic's on and make sure you're speaking into it? It's a little hard to hear.
it's actually a little bit difficult to make that direct comparison because the people going to DOC automatically they're going to have a higher OGS, they have a higher PRS. So there's some inherent differences that make that comparison difficult. So what we saw was that the SSP participants so far, I think it was like 10% recidivism for county jail, 5% for SSP. But like I said, that's hard to compare. So what we did in this study, we balanced things out. So we're looking at the whole spectrum of individuals that would have been candidates for SSP. And out of that whole group, it looks like maybe in the long term, it'd be something more like 10 to 7% comparison. So all we did was sort of balance things out to make that apples to apples. Now, the last caveat to that is that we're only looking at 18 months here. So I think long term, policy wise, with SSP having a lower recidivism rate, does that mean that we recommend judges to sentence people to DOC? No, not necessarily. It's short term. I think more than likely in the long run, these things will balance out. And it's possible that at the beginning implementation of this program at DOC, they're selecting who's going into this program. It's possible they were maybe a little overly cautious, overly selective in the first year and a half or so. And so we have extra low risk individuals that have made it through so far. And so I wouldn't necessarily expect that the SSP recidivism rate is going to continue to be half or 2/3 the rate of those going to county jail. I think realistically in the long run, they'll probably balance out. But I think the important takeaway is that this is confirming what we found last year, which is that generally these are low risk individuals. So the standard DOC 1-year recidivism rate leading to a conviction was around like 20% in our study last year. So as compared to 7% in this study. So bottom line, these are low risk individuals just by the nature of the offense types and the criteria to get into the program. But I think, just over the long term, definitely low recidivism rate, but not necessarily something where we need to make any drastic changes to the way we're sentencing to lead people in different directions.
Anyone else?
Hi.
Thanks, Ted and Brett. That very informative. I think we will start sending people to state prison. Defendants will be thrilled to hear that they'll do better off there than in the county. But yeah, I think it is the important that we come back to the chair's point, and see where we are with that sort of standard 3-year recidivism rate. But very interesting.
Yeah, and actually we, in our enabling legislation, we actually are required to revisit these programs periodically. So likely within the next couple of years, we will do a follow-up study and get that longer follow-up period, get some longer term results.
And I'll just note, since I talked about the size of samples earlier, 1,500 people is a pretty good sample, but it's not definitive in how that program works. And over time, we'll get more and more people in the program, especially those shorter tracking periods. We can track people for 12 months. We'll have a bigger sample in a year, maybe 2,500 people at that point, and then we'll have some that make it to the 3 years. So I think this is a really positive set of results for the program. It's not a bad set of results for county confinement. Actually, it's a great set of results for county confinement reentry as well. And we'll see where it goes. But I think that's why we've been framing this as a preliminary set of results because of that typical 3-year follow-up period that we have. But when they come back to the community, they seem to be doing well and not recidivating right away. And, and I don't think it's going to be a huge uptick from 18 to 36 months. And relative to the rates that Brett mentioned for general releases.
If we're going to be doing it again, just to throw an idea out there. I mean, as a sentencing judge, I'm not really concerned with apples to oranges, a little bit, but I'm more concerned about the offense gravity score and the prior record score. So when you did all that weighting, that doesn't help me as a sentencing judge. I kind of want to get a sense, okay, there are certain people that you have to send to state prison because of, let's say, even though it's a lower offense gravity score because of the nature of the crime. But statistically, when I was looking at it, and I may just be one person, I like the figures before the weight. So if there's a way that you could break it down to, let's say, simply like what you started with, this is the offense gravity score, and these are the prior record score, those ranges, I think that might help judges more than a weighted being so concerned about the apples to apples versus I think most judges know, and there's a combination of circumstances as to whether someone goes to jail or to state facility. That simply can be because of the lack of programs in the county, et cetera. But what we would like to know is, for me at least, a comparison, of once people are there, what's effective for this? Is my thinking going to be borne out by the statistics? That's also. So I'm saying if you're getting all those statistics, that might be a way. I'm not saying don't weight it, but if you could show the data in any reports, more clear delineation of the events gravity scores and the prior record scores.
That's a great suggestion, Judge. And I think like when we think about a lot of our work, we're thinking like, what would be the recidivism rate in a cell? So if you had OGS 3, PRS 4 versus OGS 4, PRS 4, is there a difference in the outcome? But to do that, of course, we need a lot of information in that individual cell to make that meaningful. We only had 17 cases to recidivate. What does that tell us? So I think long-term, absolutely. That's one of our goals for a lot of our work is to be thinking in essence, cell by cell, how do people do not just in SSP, but jail, probation? Is there a difference giving that information to the judge relative to the cell? Now, as we switch to the 8th edition, what information will be meaningful there, and the cells are smaller and the ends will be different, but that's something long-term we're striving for. And I think that would be a great tool for judges to know these people do better here or there, or this type of programming with this type of sentence on average, not at
Right,
that
and-
individual.
And for Brett, it's going to make it even more difficult because I think with the increase, it's going to be harder, I think, to do that. And I'm aware of that when we say it, but I think there will be some clear demarcation lines. And then we'll find out. But yeah, your job is going to be much harder because there's going to be so many more numbers that you have to calculate because of the increase.
So Chairman Fox, it looks like if we eliminate the board from the process, we reduce recidivism. Is that what I'm,
That's not exactly what I'm hearing.
that's what I'm hearing.
But I am seeing that is very surprising results that higher OGSs and higher offense gravity scores are actually recidivating lower rate and across the board. That's a pretty remarkable result. So it'll be interesting to study and see what's there. I'm pretty sure. With
Your job's safe
with all
for now.
respect, that Judge Marsko, I don't think.
Secretary Harry, is there anything you want to add on that?
Yeah, it is interesting to me because you wonder if the fact that they are going to state prison, if that's enough of a wow factor where it's like, okay, I really have to get it together because I don't want to come back. But we also, even though they aren't doing programming, they still have a lot of other opportunities that they may not have, whether it's religious services, educational opportunities, recreational, different things like that, that also can contribute to their overall well-being even while they're in state to hopefully get them ready for reentry. We have reentry services that would still be available to these people where the counties may not. So yeah, there's a lot of other factors involved, but it is excellent data and really appreciate it.
Thanks again. Brett.
Thanks.
Ted.
Okay, we have two things left on the agenda. Ryan will rejoin us and provide an update on the probation reform that's going on and some of his information that he's collecting and talking to different practitioners from around the Commonwealth and how long-term the role the commission might play in response to this related to our resentencing guideline.
Judge Marsico, I see that Rep Bonner does have his hand raised. I apologize. He may have
sorry.
raised his hand a couple of times.
Representative Bonner.
Oh, I appreciate the recognition, Mr. Chairman. I had a question. How are prison misconduct issues factored into determining eligibility? And who is actually performing the administrative review?
Brett.
So first on the misconduct element, I don't think misconducts necessarily come into play for someone to be eligible for the program. There is a rule for serious misconducts. You can be made ineligible by DOC staff, but generally, it's not a big part of the eligibility. And in fact, another positive we saw of short sentence parole was there seems to be some kind of a motivation factor, knowing that you've got this shot to get out earlier. There are far fewer misconducts for these individuals. And then for your question about the administrative review at the parole board, I would have to turn that over to the parole board to answer that.
Just a quick follow-up on what you just said. Do you think, however, prison misconduct issues should be a consideration? Because if it's not, and you're saying they're considered no matter what, I just wonder what type of long-term effect not considering prison misconduct may have within the program.
Yeah, there actually is a bylaw in the eligibility requirements for the program that you can be removed from eligibility through a serious misconduct. And I think generally that's how it's handled, and lower level misconducts don't really come into play.
Yeah, that's accurate. I mean, if we get someone obviously that gets into a fighting misconduct, things like that, that is serious. And so and the facilities that they go to for SSP are more of our lower level, lower risk type facilities, custody level 2, 3 facilities. So yes, they are definitely considered. I don't want to at all give the impression that they aren't and that it's an automatic that they would do SSP.
Do you have a definitive list on what you deem to be serious versus non-serious?
I'd have to go back and check with our classification staff. I think just in corrections professionals, we know what those are generally, but I can double check on that for you.
Yeah, that'd be helpful to know. I appreciate that. Thank you.
All right. Thank you, Representative Bonner. Brian.
Thank you, Judge, and I'll share a screen here. As Matt mentioned, the next item for discussion for the policy meeting is the recent Act 44 of 2023, the Probation Reform Act. I will start by saying this could be the entire policy meeting discussion. And so I have taken care to not do that to you. I thought what we could do, at least initially, is just walk through some areas that I think connect a little bit more specifically to the guidelines, the recently adopted 8th edition guidelines and our resentencing guidelines, and also highlight some areas that through some early sessions that staff have participated in or calls that we've received and certainly calls that I've been engaged with, for instance, the Chief Probation Officers Association, their executive director and other individuals, just sort of like, what does this mean? What does this look like? And frankly, we didn't have a lot of answers for that because we sort of need to see it play out. I'll note that Judge Marsico, myself, Professor Chanenson of Villanova Law, and Judge Marsico's Director of Probation Services, Chad Libby, all participated in, I guess we could call it, Judge, like a panel discussion with AOPC for a CJE session back in, I believe, March. And I think we had, well over 100 judges in attendance for that session. And we just raised a lot of questions, and we're, curious to see how counties will respond to this. What are the actions that counties are taking in preparation? And so as I go through this, I'd be happy to hear from our representatives of the counties here on the commission to engage in this discussion. I will note that Bobby and I did hold a legislative lunch and learn session May or April. And we talked through this and sort of reported out on some similar things, but in no way that we were really directing on what we think is to happen. We're just saying, here are some of the areas as a legislative service agency communicating to counties changes in statute. This is sort of what we're hearing. So let me get us going here. This slide is just a high level overview, and I promise you, I'm not going to put you through a lot of text or a lot of slides. It becomes effective next week. And I know that a lot of counties, since this was enacted, had begun, digesting the act and preparing for certain aspects of Act 44. The way that I have viewed it is that it's really sort of two areas of change. One is on the sort of sentencing or resentencing side, if you will. And that's an area in which the commission has, I think, the most engagement with the statute. The second is administrative in nature, in my viewpoint, and what I mean by that is the act amended Chapter 97 to include a section 9774.1, which in effect institutes or creates a systematic approach to early termination. That's sort of how I've been talking about it. And that's really administrative in nature and on the county and their probation department to work through processes to make sure they're identifying eligible individuals, the appropriate time frame for eligibility for consideration for termination, and all of the information that courts and the parties would need to determine whether or not somebody should remain on their probation supervision, or if the individual would be appropriate for early termination. And so it's not an area necessarily that we've spent a lot of time looking at, and there's a lot in the statute there. It's probably the biggest section of the statute. But the area that we've focused on from a staff perspective is around the order of probation, and I'll talk a little bit about that as far as modifications to the statute specifically related to conditions of probation, and also thinking about modifications to the statute when there's a revocation of probation and the limitations placed on courts under Act 44. And as I mentioned, I'll try to connect those to our existing resentencing guidelines. And then we'll wrap up this discussion with just some thoughts for members and certainly for us as staff as opportunities to see what the future looks like. What are the evolving patterns coming from Act 44? And the nice thing about this, with an effective date of June 11th, as you'll hear me say again later, we can look at, what was the landscape prior to June 11th, and then what's the landscape look like after June 11th moving forward. So there's a lot of text on the screen here. I just put the statute and sort of the change, but for me, the change here is under the conditions generally. And I think what's helpful here is this is consistent in many ways with a language adopted by the commission in the 8th edition guidelines, as well as resentencing guidelines. And for me, the takeaway is that courts are now by statute, and not to say courts weren't doing this, but by statute are to be thinking about placing conditions on the person based on their individual needs, right? That's sort of a summary of what's in front of you. And getting to that, like, what are those individual needs, making use of individualized assessments for the individual, right? Thinking about what is specific to the context of their crime and their needs. And then the latter part of the statute talking about using only the conditions necessary, if you will, right? That we're not placing too many conditions on individuals, and that those conditions really do relate to the crime that was committed and to the individual on supervision. And I say that connects to the eighth edition and the resentencing guidelines in a broader way, in which the commission, I mean, really since seventh edition, probably Amendment 5 and Amendment 6, has built in to the text of the guidelines this consideration and this an encouragement of courts to use risk, needs, and responsivity information to inform their decisions. While our framework of guidelines sets a common starting point for, statewide policy based on, two pretty, broad metrics like offense gravity score and prior record score, the commission has always encouraged individualized sentencing, consistent with statute as well, but thinking about what information can courts order and receive to help guide them in those decisions, whether it's still a standard range sentence or if there's reasons to mitigate from a sentence or depart as examples. So I thought, this is a change to statute, but it's also in many ways sort of consistent with what the commission has been doing in recent years. Here's where the language is for the modification of the revocation of probation. And this is an area in which there's been a lot of discussion over time, and we'll see what we really just we'll have to see what the courts decide, and we'll move forward there. So the big area is that there's now a limitation on a sentence, or I'll say resentence, to total confinement. So I'll step back to generalize it this way. Historically, when a person's placed on probation and their probation is revoked, the opportunities for the court at that time at a resentencing were all of the alternatives available under statute, under 9721 of Title 42. Well, this changes that, and it places a limitation on the court when it comes to total confinement. And it talks about this presumption against the revocation of probation and the resentence to total confinement, unless they're in these certain instances, set aside. So if someone's committed a new crime, there isn't this limitation, or if they commit a technical violation that falls into 6 specific categories. This is not my phrasing, but I've heard many individuals refer to them as the sinister 6 now. So I think that's the label they have received. I don't know. Maybe you need to pick a new one, and we can start promoting that. But I think the parole board, you always had your Fab 5, right? So maybe it came from you, actually.
Yeah, we did not add the Sinister 6, but we did come up with the Fab 5, which I thought was.
So we like our little phrases in the criminal justice system. But so nonetheless, that's where you see this total confinement limitation. And here in statute are the 6 categories of those technical violations in which there wouldn't be this limitation of total confinement. And just in short, whether they're sexual in nature, there's assaultive behavior, did they possess a firearm, were they engaging in the sale of drugs, absconding from supervision. Those are sort of those 5 that we always sort of have historically thought about. And then you have this 6th one that's one where we still are waiting for interpretation, I guess, in which a person has intentionally, failed on supervision, like they're just not complying on 3 or more occasions. And I think of these as those sort of general conditions of probation. So you're not showing up, you're failing drug tests and so forth. And so that's been an area just, and I don't want to dive too deeply into it, but that's been an area, and I know Judge Marsico and I've had lots of discussions around various interpretations across the state on what those 3 or more separate occasions mean in relationship to the actual limitation on the total confinement. And this is where you see if a court is going to revoke the person and sentence them to total confinement, we have this first, second, third, or subsequent violation language in statute that's connected to a period of time. And so for a first violation, you see 14 days. Second violation is 30 days. If they're in front of the court for a third or subsequent, that's when we kind of go back to the way things were, which is the court has all the options available to them that they had at the time of the initial sentence. And then there's some carve outs to say if the court determines the person's, in need of or is sentencing them to, say, a problem solving court or treatment, there's you can extend those periods. So I'm not going to say much here other than we're sort of in like wait and see what this means. There are differing interpretations of what a revocation and a resentence looks like here, as far as are they just going for 14 days and coming back out on probation, or is it an actual sentence to 14 days? So I think we'll have to look to our trial courts and their interpretation, and then I suspect our appellate courts and their interpretation of the trial courts. The one thing I will note here, though, is if you look at the statute, it's very specific in total confinement. And so when you look at Title 42, Section 9721, there are other options available to courts prior to the use of total confinement. So, you have obviously guilt without further penalty, fines, probation, and partial confinement. And so I think when we're looking at the statute here, it's important to note that it uses the term total confinement, and that's, specific within 9721. So I think there's still a lot of, discretion and availability for the court. I think the intent of the legislation was to guard against revoking probation and sending somebody in effect to, for example, to state prison for lesser violations. So I'll keep moving because I know we have other topics to discuss, but let's shift to the guidelines for a moment to say the commission for the first time adopted and resentencing guidelines became effective in January of 2020. So January 1 of 2020. And quickly thereafter, we had to amend the guidelines because of Act 114 and 115. And it was really just technical in nature of removing county intermediate punishment, state intermediate punishment language. But so the commission's resentencing guidelines are fairly new. If you think about it that way, what happened in March of 2020 and what carried through. And so, the resentencing guidelines were effective for offenses committed on or after that date. So the person would have to have committed an offense in that year, placed on probation, and then been subsequently revoked. So there's been some time for those policies to take effect. So we're still, in my view, sort of in the early years of our resentencing guidelines. As part of the 8th edition suite of guidelines and the commission adopting the 8th edition sentencing guidelines, also adopted what we've talked a lot about as the new resentencing guidelines. And what we meant by that in the end was the commission really just adopted a bright line and said, for offenses on or after January 1 of this year, if they're placed on probation, fail on probation, or are revoked, that's all linked to the 8th edition. Anything that precedes it would be linked to the 7th edition. And so, from a policy perspective, there really isn't any difference there. It's just making sure we're looking at the right matrix and the right OGSs. What is the commission recommending around resentences? This is just a general, quick review. First, we look at technical or new conviction, and that's pretty standard. We are focused on if a person's committed a new crime, that they were convicted of the crime. But we're not looking at arrests here. So a person might be arrested, but if they're not convicted, that's not going to elevate to a new conviction violation. It would remain in that technical space. As I mentioned earlier, the commission has, now for 4 years, talked about the use of additional information. So when it comes to the resentencing guidelines, it's in the text of the guidelines that at the time of resentence, the commission, is recommending that the court obtain risk needs or risk needs responsivity assessment or some other type of assessment to help inform them on what they should do with this person. A person's been placed on supervision, has failed on supervision, and so it might benefit to know more about why they're failing on supervision and what are the options that you then have at that time to address those. So that's all, again, sort of, I think, consistent in many ways with the new statute. I thought I'd give you just a few examples of the mechanism of the resentencing guidelines because we haven't talked a lot about them. So I'm showing you 7th and 8th edition because we are still in these two worlds for some time. For a technical violation, what the commission is saying is that if the person has a technical violation at the time of a resentence, we're recommending the court consider what the original sentencing guidelines were. So that's what you see here under the 7th edition. You have the original sentencing guidelines. I chose an OGS 5 and a prior record score of 0. the standard range at the time of the initial sentence was restorative sanctions up to 9 months. Or if the court was going to sentence to probation, the commission would be recommending probation of 2 years. That's the standard range. So in this example, someone obviously received probation. Right now, they're back in front of the court for a violation and a revocation, just a technical violation. Then the commission is saying, revisit what the initial resentencing guidelines were and rinse and repeat that with the 8th edition. Again, I just chose the OGS 7, prior record score of 0. Recommendation was for 24 months of probation. If they're being resentenced for a technical only, then the resentencing guideline is 24 months of probation. Here's where you see the change in the recommendation, at least from the commission. And this is relative to the person's type of violation, that it's a new conviction. And so when the resentencing guidelines were adopted or developed and adopted years ago, it was an indication that if you've committed a crime while on supervision, that elevates the recommendation. That's clearly more serious than technical violation. And so for a 7th edition example here, using OGS 5 and prior record score 0 again, you see the initial sentence recommendation. And if they have a new conviction, the way in the 7th edition to provide for a increased resentence recommendation, the commission moved left to right on the prior record score. It wasn't an indication that we were increasing the person's prior record score into the future. It was merely a mechanism to increase the recommendation. So you would see this change from RS to 9 to 1 to 12 months. In the 8th edition, because we changed the framework of the guidelines and the matrix more specifically, we wanted to make use of the ability to step up with OGSs, and we sort of abandoned this moving of prior record score. And so you'll see the change from 24 months, moving from a 7 to an 8 to give us 1 to 4 months of confinement, or the trade-off of restrictive conditions, probation with restrictive conditions in lieu of county confinement. So that's just the way in which we come to a resentencing recommendation. So here's the final slide, and certainly available for any questions. Some questions we may ask, and these are questions that have been raised in sessions and conversations that we've had with counties. Will we see court sentencing differently? The administrative review conferences require administrative reviews at least 1 year or half of their probationary sentence, as an example, and will we see changes there? And that's just at the initial time of sentencing, something we can look at. As I mentioned earlier, we'll have the opportunity to look at, are there just changes around resentences more generally, starting June 11th and afterwards, because of the limitations on total confinement and so forth. And we can take a look at that certainly by state and to some degree by the county level. So those will be interesting questions for us as we move forward. And then I'll wrap up and say, because I already talked about it earlier, we'll continue to work on enhancing our resentencing information that we collect. And that's part of, this process moving forward. We have required courts to report that to us since 2016. And we continue to get better and better, though we still think there's some counties that could do more. And we will also internally be looking at SGS Web to make sure that from a programming standpoint, we don't have any barriers for counties to report resentences to us. And why I say that is, if there's any areas in which we're sort of in opposite of the statute, because keep in mind, the guidelines came before the statute, and the statute may have created some barriers that would be sort of inconsistent with what the commission is recommending. And so what we want to make sure we're doing is we're producing the information based on the guidelines for the court's consideration, but that we're not limiting counties reporting the information to us if they're following the statute. So, it may be, this is not to get too technical, but it might be simply just allowing them to provide a reason that this resentence is due to Act 44 or something to that extent. And then we're able to collect that information internally. So there was something else I thought I wanted to say, but it escapes me now. And I'm sure you're good on listening to my voice here this morning, and I'll take a sip of coffee and I'll turn it to the chair if there's any questions.
All right.
Comments.
Anybody have any questions for Ryan? This is a sea change with probation. Thanks to our friends here in the legislature, Meek Mill, specifically Jordan Harris and Cheryl Delosier, who I consider friends, but I'm cursing now that this legislation is upon us. And there's a whole nother aspect for the practitioners dealing with probation review conferences that doesn't affect anything we do here on the commission. But I think, a lot of this is going to be interpreted by Judge McLaughlin and her colleagues down the line, to tell us exactly what some of this is. But that's some good changes to the law. We'll just have to see how it plays out. Any questions? That? All right.
Thank you. And thank you, Ryan, for the overview. Well, my first question, could you talk a bit, because I think in hearing you speak about it, seems like some of the confusion is around, like, the commission has the recommendations and the guidelines, but then there's also the statute, and how do you balance the guidelines of the commission alongside what's required by the statute and what's listed there. So how do you balance those two different things when there's obviously discrepancies due to the legislation and the sort of the recommendations coming out of the guidelines review?
Sure, thank you. So I'll answer in two ways, and I'll try to be pretty direct and short here because we're running out of time. But one is there's been confusion, not about the guidelines first. I'll say this, there's just been confusion about some of the text of the statute and what it means. So setting that aside, to your point, Representative, there may be some inconsistencies, and I haven't gone through all the permutations of like what a revocation could be relative to the guidelines. But one thing to keep in mind, and fundamentally, and I think this is where we aren't in a position to necessarily do anything or recommend anything to the commission at this time, is anytime there's a mandatory, and if you look at the limitations on probation for total confinement, you might think, well, that's, a mandatory provision that the courts cannot sentence beyond that. Those supersede the guidelines. And so, the guidelines are advisory in nature, much like the DUI discussion we had earlier. While a commission may have guidelines around a DUI, the mandatory penalty provisions in statute will supersede guidelines. And so, that's sort of the starting point. And that's why I mentioned, as we look at our application, I think it's important for us to recognize when that may occur and allow courts to report that information to us. And I think for now, we have to wait and see how this plays out. And we might find that the way our resentencing guidelines work, those limitations or those terms may be in, part of the standard range recommendation anyway. So I think we just have to monitor as we move forward. Yeah.
And another quick one, and honestly, this might even be more for the practitioners than the commission. I'm curious about one of the things that was just mentioned to me was maybe some confusion around the listing of the technical violations and how all those subsequent ones result in the different confinement levels. And just is that, and again, the judges might be in a better position to answer this, like, is that causing any conflict with kind of previous just practices around how you or couple those violations?
Oh yeah, that's the 14-day limitation is a big change. I think it's going to vary county to county. I'm sure, when we did the webinar that Ryan referred to, we actually had a judge from a smaller, more rural county, because I thought it was important to have their perspective on this, where they might be more apt to incarcerate someone on probation violations than other counties. And the language that it refers to them as technical violations in the statute, I don't necessarily consider having a gun a technical violation, or that type of stuff that now is characterized as technical violations. The last one of those 6 that Ryan had up there is what I'd always consider technical violations. Someone doesn't show up to meet with their PO, someone misses a drug test, that kind of stuff. Now, my reading of it, and different people read it differently. I think that's why I said Judge McLaughlin and her friends are going to be key in telling us what this means. To me, it reads now you have to have 3 of those missed appointments, missed urines, 3 technical violations to count as one. And then the limit's 14 days. Now most places, I don't think a lot of people are getting locked up for missing an appointment, 1 appointment or 1 urine. But the limitations there are significant. There's concerns. Individuals have expressed, I have a treatment, I do our drug treatment court, individuals there that sometimes, frankly, there's nowhere else for them to go. They've relapsed and they end up incarcerated until we can get them a bed. Now do we have to kick them out after 14 days? Or can I even put them in prison, for relapsing unless there's 3 separate violations? So there's some things to be worked out here. I mean, I watched this legislation play out over the course, I think 6-7 years. Used Center Street, can refresh my recollection on that. So there was different things, that went through it, but yeah, it's going to be a work in progress. Senator?
Yeah, so look, I'm glad that we're looking at the implications of Act 44 on the guidelines. Couple of things. One, do you think that we need to start looking at possibly updating the guidelines to remove inconsistencies with Act 44? And that may be premature because we may not be fully abreast of what those inconsistencies are. And then 2, sort of a corollary to that is, do you think that perhaps there should just be some clarifying language, not sort of additional clarifying language added to assist in implementation of Act 44? Because we spent a considerable amount of time as a legislature on this, ping pong back between chambers, and was probably one of the more bipartisan, bicameral things we've done. That being said, ultimately the legislature only cuts with so fine a tune a scalpel. We usually our scalpel is like a chainsaw. So some point somebody needs to maybe fine tune what we've done a little bit, make it a little easier for practitioners to use.
My thoughts on that would be, I don't think we need to do anything on the guidelines yet till we see out to your first question on discrepancies. And to the second question, I think that's going to have to play out probably in the courts, with the way the legislation's written. And I know, you, Center Street, Senator Baker, championed this through the Senate. It's just, there's just some, I think, things that are going to be changes, whether that results in litigation that we need either legislative clarification or appellate court clarification. I think we have to sort of wait and see right now. I think we're well aware what the intent of the legislature was. It's just, the final drafting, there's some confusion.
And we will have some cases coming up.
And I was just going to add, for a lot of us, depending on your jurisdiction, there is not going to be any real difference because of internal policies like that we've had in Philadelphia, where we don't even get notified of technical violations until there's numerous technical violations. But I think Judge Marsico's point is well taken. There are always exceptions to the general rules, and there are those cases that are going to come up that express concerns, but that like a possession of a gun. Now, hopefully you would say, okay, they're going to get charged with that and they're going to get convicted of it. So then I don't have to worry about dealing with it this way. But things, that may come up. But I do want to add my 2 cents to the change in the guidelines. And look, we've done such a massive change. Right now, it's going to take, I would say, a minimum of 2 to 3 years for the judges to just get used to the new guidelines, the resentencing guidelines. And even though the Superior Court's going to get those cases, I think they're going to be very limited, and it's going to be 2 to 3 years before we get any guidance from Superior Court. And so I would say, let's just see what happens. And I think that's what's great about the commission staff, is that they're going to be able to tell us, okay, we've gotten these phone calls, this is what's happening there. So I think it's an educational process for all of us. and hopefully we'll have more input. And I don't even think it's going to be 6 months. I think it's going to be a minimum of a year before people get worried. Now, again, I don't speak for every judge throughout the Commonwealth, and I'm sure there are going to be judges that, well, I will just tell you, generally judges cringe when they feel that their authority and their control and their, to use an appellate court, we do not have unfettered language from the appellate courts, and she's sitting right next to me, one member. We do not have unfettered discretion, but we like to have a lot of discretion. And
Agree.
that's being limited.
Thanks, everybody, for the input on this. And again, it's landmark legislation. So kudos to the legislature, putting a lot of work to get us here. Now we'll try and implement it.
Great. Thanks, Ryan. We want to, in the next 10 minutes, we're going to just give a quick overview of 2 new initiatives that we've come up with. So Bobby will do 5 minutes, I'll do 5 minutes. And I think this, as I noted it in the introduction, this is a great area to lean on our standing committees. So the Education and Outreach Committees chaired by Representative Bonner for what Bobby's going to introduce. And certainly I know that the chair has great interest in this as well and getting his input. He is a member of that standing committee, so that would be great. And then for what I'll talk about, Senator Langerholtz chairs the Research and Data Analysis Committee and getting dialogue on that. So we're going to give a really just quick overview of these 2 initiatives. And so I'll turn it to Bobby fast for 4.5 minutes now.
There we go. There we go. All right. So just to set the stage a little bit, one of the areas that we're looking to possibly grow a little bit is our engagement beyond just our practitioners and focus more on the general public in our engagement with individuals. And we'd really like some guidance from the commission. So with that, I had some questions on the screen, and really what we're looking for. And as Matt mentioned, we'll certainly lean on the committee that we have, Education and Outreach Committee. But more globally, we're looking for some direction on, what is our general frame that we're looking to occupy. Are there certain events or venues or groups that we should be engaging with? So, I'll lead with those 2 questions first. I think they're related to one another. If any of you have some feedback, some suggestions, that would be helpful for us as we're building out what that might look.
I assume you've looked to other commissions, because my initial response is the guidelines are really complicated.
Right.
The newer ones, the guidelines, it takes the attorneys a significant amount of time to be able to convey to a client, and even I do in the courtroom, for what the guidelines are, so they can make educated decisions about guilty pleas or non-trial dispositions. I think we always want the public to be aware of what we're doing, but sometimes if you get too much information, and it gets too complicated, it basically engenders a misunderstanding, and you might get a lot of backlash from certain segments of the population. So I am curious that being said, I'm curious to see, what do other states do?
Yeah.
I
And
mean, have you looked to other commissions to see how they've engaged the public?
yeah, we've looked at other members of NASC, and there are some that do limited engagement with focusing more on the general. There are some commissions that have like YouTube and even Instagram, which was kind of surprising, and more direct public engagement. We're building out our YouTube content, something I'll talk about at the business meeting. So we think we have some area to provide some more general information to the public. The general case flow in Pennsylvania might be helpful, because we get some confusion questions from people asking, where do I go with X? So I think having a base level of information for the public would be helpful. I agree, the guidelines are a little involved, and we have other offerings on our website with e-learning and other content that we're regularly developing in the unit that I think will serve that purpose. But you know, we're just kind of looking to see if we're missing any other marks to be more proactive.
Thank you, Bobby. This is an exciting initiative to hear you guys embarking upon. I think taking Judge McDermott's thoughts about into consideration around how complicated the work of the commission is, definitely trying to figure out how to start slow and even have community engagement just be just basic information and just as basically informative as possible is probably the right way to go. And I think also where might there be opportunities to also collaborate with just local government and local elected officials as well? Because I mean, my city council doesn't even know what the commission is, right? So like they should know too. They're also a part of the community that I would be engaging with if we were to do something in Philadelphia about the work of the commission and what it does. So I think maybe something where we kind of slow roll it and it's like even doing some collaboration just with other local governments, local structures to say, hey, we're coming to your community to talk about, us as a, legislative agency, legislative body that does work that, you talk about all the time when you talk about criminal justice. So I think, starting slow and not getting too much into the granular is probably the right way to go.
And Judge, I think your point's well taken. So the National Association of Sentencing Commission meetings coming up in August that Ryan will talk about. Representative Krajewski actually will be on a panel with some other jurisdictions talking about what they're doing in DC. And I think it's an opportunity for us to learn from other spaces, get some ideas, talk to some other folks and, Bobby's parallel in other spaces and find out and maybe use that as a little bit of a template for a starting point and bring that to our standing committee.
My fundamental concern is release of information is always good, but if you start develop or expending resources? I mean, my perspective is the Sentencing Commission doesn't even have enough resources now. Where do you find that balance? That would be my concern because I know how busy you are. I know how busy you guys are and you're going to be, the influx of the calls to the help desk, I'm sure is starting to trickle in, but it's going to be, I would say at least quadruple, whatever that word is, at least geometrically increasing over the next year. And then I know we've got funding issues for just the web and everything else. So I think release of information, dissemination with the public is always good. But my caution would be, let's not make certain that it's at the expense of the fundamental mission of the Sentencing Commission. That's all.
Yeah. And I would say to that point, a lot of the material that our unit developed, like frequently asked questions, reference guides, are already in existence. So, we could just point to not reinvent, but point to what we've already done if that's useful and distilled a little bit. Sorry, go ahead.
Yeah, I was going to add that if I think sort of echoing Representative Krajewski, I think that outreach and increasing stakeholder understanding of what's going on is great and certainly something that we should encourage. And now's a good time to ask for money. So if you're going to ask, just build it into your request while we still have lots of money.
Yeah, thank you.
And Matt, a natural partner for disseminating information are the Criminal Justice Advisory Board. Some counties are more sophisticated than others. Virtually every stakeholder is in the room. Allegheny, we've got about 38 folks, human services, victims, probation. I mean, everybody, it's everybody. So I think that's probably a good place for you to park some of your ideas to show how everybody in that room has an impact on these guidelines and vice versa. So I think that would be a good body to talk to.
Yeah,
statewide.
Yeah, that's a good suggestion. I know from my time with Dauphin County, PCCD was often
Absolutely.
involved a lot with them, and maybe that's an area where you can expand
I think
a little bit.
PCCD and CJABS, you could do a lot there.
Right. Thank you.
All right, so we'll continue to explore this, and I appreciate the opportunity just to start the dialogue on this really important opportunity and what the judge noted about limited resources. We envision this as very targeted, 3-4 events, to start, not every week doing something. And so baby steps to not overwhelm us. Okay, I'm going to go through this really quickly, and I think we probably all know a little bit about what I have in mind, but staff did a little bit digging, and just so you get an idea, like the Pew Research Center on the left there has very quickly, you could see if I told you those are violent crime and property offense arrests, they're on the decline. You don't have to read a lot about it. You could just see it. And then I think just to highlight the Philadelphia District Attorney's Office actually does an amazing job with their data displays. They have a lot of information available about charging practices and so forth. And then I'll show another example from Maryland. And again, you could see from a design principle, not a lot of words and a quick visual. The recidivism rate is on the right from this study from the United States Sentencing Commission. And you could see after 8 years, recidivism rate's 50%. Year one, it's 18%. So how to have our information in a way that's either on a web page for a specific target, or what one of my mentors would say, do you want the doorstop or a 2-pager? And how do we get a 2-pager that's really easy to consume? And here's one from Maryland. They do an amazing job. Their commission staff has about 5 or 6 people. This is, from my perspective, pretty busy, but it provides a quick profile of second-degree assault in Maryland. A lot of information, what percentage of cases in Maryland are second-degree, what proportion of cases involved a weapon, what type of sentences they receive. So this idea of presenting information like this is not foreign to the commission. This is some of the work we did for the 8th edition guidelines. On the left are what type of sentences and durations individuals receive for different types of drugs by different weights. So we look at the bottom and we have cocaine. And one of the things we talked about as a commission based on this is, could there be different cut points based on weights? You see the bottom 2 bars are very similar. We did some work on burglary where we looked at what the OGS assignment should be. So we have on the top burglary, not a home, no person. You see it ranges from restorative sanctions all the way up to state prison sentences. And then burglary, home, person present, very tight, but the median is different. We see a short 4-month confinement period for not a home, not present, almost 12 months for person present and a home. So that helped us out. And we have lots of ways, even the thing that Ryan presented about certification, we're trying to be visual with less text. So I just threw together a quick list of topics off the top of my head that one could think about. We could do this profile of drug offenses. We've talked a lot about pattern offending or pattern reoffending. I've been interested in, since the strangulation statute was introduced, the difference between simple and aggravated assault and where strangulation, how is it being used, what type of sentences are being imposed, et cetera, et cetera, et cetera. So I think this is an initiative that we considered, again, of having between 2 or 4 of these a year, not every month. Brett's unit digging in. And I think we could really leverage our standing committee. Part of my hesitation is, what if I chose fines, fees, and restitutions, and we presented that and you guys said, why were you focused on that? Just some way to get some feedback of what seems important and what we should prioritize. But these are very doable. And again, they could be in our conversations, as Bobby and I have been traveling around talking to different staff in the legislature, highlighting a topic that they're not even aware of, that then they could understand, like, hey, here's the sentencing patterns for strangulation. That's not even something we've considered, or however it is, but really easily digestible and consumable in the vein of something not like that, maybe, but clean, crisp data with a little bit of words. So I don't think we need to necessarily belabor the conversation, but I think it's something that we can be doing. We do the annual report, of course. It's a tremendous, voluminous amount of information, data after data of numbers. Something more digestible is really what I'm looking for.
I think it's a great idea. I think that's, we've all turned into visual learners. So I think it's important, whether it's coming up here on the Hill to present like strangulation. All right, legislature passed that a few years ago. Let's see what the impact is on it. I think that's a great idea. And I would encourage anyone on the commission to let Matt and Bobby know what ideas you have or you'd like to see, in that regard, either in the data snapshot or with community engagement.
Yeah, I'll just make one last comment on this, which is, there's a real move to using maps and putting information on maps, hotspots for arrests. Our unit of analysis is counties, so it's a little bit less interesting to have things at the county level. One example, though, that is kind of interesting, and we heard last night, is just where are locations of veterans treatment courts we get this project, and where are VAs and other resources for these counties. So, when we were in Cambria, it's nice that the resources are in Altoona. It's like a 15-minute drive, 20-minute drive. So do you have a veterans court only where there are the resources, or how does this all work out? So we're kind of exploring other options for displaying information, but that's a little bit of a skew from kind of like our traditional sentencing information, duration, conformity rates, different aspects related to different offense types or what it might be.
All right. Well, with that, I think we can adjourn the policy meeting, take a 5-minute recess, which will, I'm sure, segue into 8, but let's take a break now. We'll come back at what time? All right, 11:15, come back.